Okay, welcome to part two of our Wills and Trusts Inheritance podcast. And in this second part here, we're going to go pretty deep into the weeds of the various ways that you can inherit an estate in California. Once again, remember, we're only talking about California here. Laws in other states are somewhat different. And also, you should remember that in the first video in this series, I talked mostly about debts that are owed at the time of death and how those debts are paid and which ones have to be paid and which ones you can avoid payment. Uh, but I didn't really get into modes of inheritance much in the first video. So in this video, we're going to talk about the 6 different ways that you can inherit an estate from someone. And keep in mind that when we use the term estate, that has a particular meaning. Estate is all the cash that somebody has when they die, all the what are called cash equivalent or cash convertible accounts that they have. That includes stocks, bonds, money markets, and all of the real property that they have that has value. That can include a house or a boat or a car or any combination of those. So when people die, their entire estate is valued. That is, there's usually an appraisal that values the entire estate, all the accounts, the cash, the real equity in the real property, and then you add all that up. Now, if the total estate value, when everything is added up, is less than about $200,000 in California, that's what's called a small estate. And small estates can be passed on through what's called the small estate transfer process, which is where basically the executor of the will for the estate just files a small estate transfer form with the courts, testifying that the total estate value is less than the minimum for probate in California, which is a little over $200,000 now. And if that's the case, then you can do this small estate transfer. It's a very simple process. It's just filing 1 or 2 forms with the court and paying off debts, because you still have to pay off debts from the estate value that the person had at the time of their death. And then whatever's remaining can be distributed according to the will. Small estate transfer, by the way, is assuming that there's a will, which, as we mentioned last time, there should always be, pretty much, unless you just don't care how your assets are distributed after you die, or even whether they go to the people you want them to go to. So the easiest way of passing on an estate is, if it's a small estate, doing the small estate transfer. The nice thing about small estate transfers is that the process is over very quickly. Basically, as soon as the debts are paid off, you can take the remainder of the estate, the remainder of the money, and just distribute it according to the person's will. And that usually can all be done within 2 months of somebody's death. So pretty quick by comparison to some of these other methods. Now, we also talked a little bit last time about what's called intestacy, which is where somebody dies without a will and without a trust. So if the person who dies does not have a will or a trust, but they do have an estate, then the way that the estate is distributed is specified in California law. And it may or may not be the way that you would want it to be distributed. So in general, this is covered under this last column here, whereas the small estate's covered under this first column here. But in general, when somebody dies intestate, meaning without a will, without a trust, you still have to satisfy debts. So any legal debt that the person owed at the time of their death has to be paid out of the estate. But in this case, if there's intestacy and there's no executor named, then the state will have to appoint an executor for the the estate distribution. So the state of California, will have to appoint an executor for the estate. And then the executor will satisfy debts from the estate. And then there's laws of intestacy, which specifies the order that folks will get money and property if there's any remaining after debt payments. So for example, in California, whatever's left over after debt payments, the surviving spouse gets half of it. And then the other half is distributed evenly to the closest remaining relatives of the person. And there's an order to how close the relatives are. It starts with kids. Once you get beyond the spouse, it's the kids. Then I think it might be the parents, then brothers and sisters. But in general, if there's at least one person in one of those groups, then the person who's in the group that's the closest to the person who died is going to inherit what's left. Or if there's more than one person in that group, it's split evenly among them. So for example, if I die and I have 2 kids, but no spouse, that means that each of my kids gets basically half of everything that I own. And we don't need to, since I had 2 kids, we don't need to go beyond the kids and look for other surviving relatives. Now, if I had a spouse at the time of my death, then my spouse would get half of everything I owned, and then my 2 kids would split between the remaining half. The exception to this rule is if something is jointly owned at the time of death. So for example, if I have a house that I jointly own with my spouse, then my spouse would then get 100% of that asset when I died. So my spouse would get 100% of the house, and then if there's remaining cash, for example, my spouse gets half that cash, and my kids they split the remaining half. An interesting situation with intestacy is if no close relatives can be found, that is, no spouse, no kids, no parents, no brothers or sisters, then the entire estate can be given to the state. That is, the state of California can just take the entire estate. So if you don't want your estate distributed that way after you die, then you really need to write a will or a trust or both. By the way, you can have a will and a trust. And I think we talked a little last time about how there's differences in the things that you can specify in wills and trusts. For example, in a will, you can specify things that are non-monetary, like who gets custody of kids, of minor children, or what kind of funeral services you want and where you want to be buried. That kind of stuff can be specified in a will, but not in a trust. Trust documents are really just for distribution of financial assets. Okay, so let's assume then you're not intestate, that is, there is a will or a trust, and that your estate is not small. Then there's 4 more remaining ways that things can be passed on in that eventuality. You can do what's called a pay or transfer on death accounts. You can do a will plus probate. Now, if you just write a will and don't create a trust, and your estate is more than the minimum value for probate, then it's automatically probated. So if I wrote a will, I didn't write a trust, my estate's worth more than $200,000, then my estate automatically goes into probate. You can also write a will and do a trust. And there are 2 different kinds of trusts. I think we mentioned this last time. One is called revocable and the other is called irrevocable. So of the 4 remaining ways that estates can be passed on, there's pay or transfer on death accounts, there's a will and probate, there's a revocable trust and a will, there's an irrevocable trust and a will. So let's talk about each of those separately. starting with the will and probate. So we'll go right to the one in the middle. This is the most common way in California, I think things are passed on now, is somebody writes a will, but they don't actually create a trust, and their estate's worth more than $200,000 at death, so that the estate then goes into probate. Now, in probate, you have what's called an executor, who's the person who administers the estate and has to take it through the legal process of probate. Probate is a court process. Okay, there's a bunch of documents that have to be filed with the probate court, which is a real court in California. In fact, each county in California has its own probate court. So you have to start filing things with the probate court. There's lots of different filings that have to be done, and they have to be done on time. There's a certain time frame that things have to be done in. And because probate involves a bunch of court filings that have to be done on a schedule, with the proper forms filled out and everything else, in California, it's required that any estate that goes through probate, the executor has to hire a probate attorney, a will and estate attorney, basically to help with the probate process. That's not an option, that's a requirement. So, for example, if you're going to take a will through probate, the executor, you're the executor, you have to first hire an estate attorney. The estate attorney is going to want money, and they're paid out of the estate value generally. So, and their payment is substantial. They get to take a significant little piece of the estate for their troubles in getting you through this process. So, although wills are very cheap to set up, you can set up a will for a couple $100. The probate process is expensive. You have to hire and pay probate attorneys. They're paid as a percentage of the estate. And then there's all kinds of filing fees and other fees, and and the executor gets paid as well. So although wills, if you just do a will and not a trust, it's cheaper on the front end. It actually turns out to be much more expensive than a trust on the back end because of all those extra fees and the attorney's costs and stuff that you have to pay. The other thing about doing probate is an open court proceeding. That is, everything that's filed with the probate court is anybody who wants to look at it can look at it, which means none of your estate things are private. Your estate valuation is public. Who gets what is public. How much each person inherited is public. So there's a lot of folks, particularly folks with more money, that don't want that kind of information made public. And so they prefer not to do probate. They prefer to do trusts, which can remain private for reasons we'll talk about. Of course, when you take an estate through probate, the first thing that has to happen is you have to pay off the creditors. So any money that's owed by the person who died at the time of their death has to be paid from the estate. And then there's a mandatory waiting period for creditors to make claims against the estate. There's a mandatory challenge period for people who want to challenge the will. And then there's all kinds of documentation about the valuations of various parts of the estate and more court filings. And then when you finally get towards the distribution, you have to file an intent to distribute. This all takes a long time. There's lots of delays at the court level because the courts are kind of overwhelmed right now with estate filings. So just on average, it takes at least a year and a half to get through the probate process. And this is something that you should really, if you're an executor ever on a will, the first thing you should tell everybody who's a beneficiary of the will, everybody who stands to inherit something, is tell them that, they got to cool their jets because they ain't getting anything right away. Unless it's a small estate or there's a pay or transfer on death account, these processes take a long time. And the executor legally can't pay out the beneficiaries until this process is over. In other words, if an estate's going through probate, nobody can get paid from that estate except for the executor until the entire probate process is finished. And on average in California, that's 1.5 to 2 years after the person dies. So, you may get all excited. You found out that you're inheriting some money from, somebody, your uncle who died, but your uncle's estate has to go through probate. You aren't going to see a dime of that for at least 1.5 years. So, just chill out. Let's see what else. Yeah, I think that's pretty much it for wills and probates. So again, if somebody dies with a will and their estate's valued over $200,000, but they don't have a trust or pay on death accounts, then you're going through probate, and there's no way around it. And it's going to take a long time, and it's going to cost a fair amount of money. Okay, so there's ways of avoiding that long legal process. One way, and this actually is one of the better ways, which a lot of people don't know about, is to create what's called a pay or transfer on death account. And you can basically turn any account or any property asset into a pay or transfer on death account or asset just by filing some paperwork. For example, if you have, let's say you have a bank account, a checking account, or a savings account, it has $100,000. And you want one particular beneficiary to get all of that money pretty much right away after you die. Maybe you want your executor to get it so that they have money to pay your other bills and do stuff with right away. You can make that savings account, you can file some paperwork with your bank and make that savings account what's called a pay on death account, which means that as soon as you present the bank with a death certificate for the person who owned the account, then the bank will quickly transfer that account into your name or set up a new account where all that money goes into the account in your name. And that can happen very quickly, usually within weeks after somebody dies. So if you want somebody to get some money very quickly after you die, setting up pay on death accounts is very, very useful. You can also, by the way, set property as transfer on death. Again, you have to file special forms. This isn't done automatically, even if you co-own a property. So, maybe you co-own a property with somebody. You still need some language in there that's a transfer on death language, which will mean that your share of the property will automatically transfer to them after you die. And as soon as you present the bank or the lending institution or whatever with the death certificates, they'll just transfer things over. One nice thing about transfer on death accounts or pay on death accounts is they do not count toward the probate limit. They're considered outside of probate. And so, for example, let's suppose I have $100,000 in a savings account, and then I just own property, but I have like $500,000 in equity in that property. Well, that $500,000 in equity plus the $100,000 in my savings account puts me over the small estate transfer limit. But if I take that property and make it a transfer on death property to, say, my spouse or one of my kids, then that $500,000 in equity doesn't count toward probate. And so all I'm left with is then $100,000 in the savings account, and that's below the small estate value. And so we can just file small estate to distribute the rest of that and make everything go very quickly. So there's a number of advantages to doing pay on death or transfer on death designations for various accounts. Can prevent you from going into probate, and it happens very, very quickly. The transfer occurs very quickly after death, usually within weeks. So that's all really good. You don't have to wait the 1.5 years for probate and pay all those attorney's fees. So you might think, well, that's great. Why don't I just do all my accounts and everything as pay or transfer on death, and then I don't have to worry about it? You could do that. But here's the problem. If you want to split things up in particular ways among your beneficiaries, you might not be able to use this process, because for each account that you have, you can only designate one beneficiary as pay on death or transfer on death. So just one person. So for example, if I had, let's say, a savings account with $200,000 in it, but I wanted it split evenly among my 4 kids, I can't do that with a pay on death account, because you can only give that account to one person if it's pay on death. You can't give it to 4. And since most people actually do want to kind of split up their assets more like that, that's why pay or transfer on death accounts aren't used as much as probably they should be, is you can't split them up any way you like. The other thing is, and you should know this, is that even if something is designated pay or transfer on death, if you die owing money, if you have debts on death, the debtors can still collect from those transfer on death accounts. So just because an account is transfer on death doesn't mean it's immune from creditors. Your creditors still can get the money out of that account. So it's still subject to creditor rules. But it's actually a form of transfer that I think people don't know much about, and so don't use as much as they should, because it really has a lot of advantages. But keep in mind that whatever it is you want to transfer that way, you have to fill out special paperwork. It doesn't happen automatically. There's always special paperwork involved that has to be filled out before you die. It's got to be notarized and signed, and you have to do that before you die. If you haven't done your transfer on death forms before you die, then that's no longer an option once you die. Okay, now that just leaves us with trusts. And there's 2 different kinds of trusts. I think I mentioned this last time. There's what's called a revocable trust and what's called an irrevocable trust. And so we'll talk about both of those. By far the most common is the revocable trust. Keep in mind, though, that trusts often come with wills. So it's not like you do one or the other when you say will and trust. It's will and trust. Usually, if you have a trust, you're also writing a will. And part of that is because, as I think I mentioned during the first video, there are things you can specify in a will that you can't specify in a trust. Trust documents can only specify transfers of financial assets, real property, things that have monetary value. But if you want to specify things that don't have a valuation, you have to use a will. For example, if I have minor children when I die, and I want to specify who's going to take care of my minor children after my death, I have to use a will for that. Trust documents cannot be used for that purpose. You also, for example, cannot use a trust document to specify something like where you want to be buried or how you want to be buried, what kind of service you want, what kind of casket you want. Those kinds of things have to be specified in a will, not a trust. So again, almost everybody who does a trust also does a will. To specify things that can't be specified in a trust, usually, and also to really clarify your intentions regarding things that might otherwise be a little fuzzy. But I wanted to talk about the difference between a revocable trust and an irrevocable trust, and a little bit about what a trust is. So a trust is, you can think of it like a box, a big giant box, where you put a bunch of your estate before you die. So you put a lot of your estate before you die into this big box. And when it's in the box, it's immune from certain things. For example, even a revocable trust is whatever you put into that trust before you die is immune from creditors until you die. So let's suppose I owe money to a bank and I don't have the money to pay. the bank. But I have put all of my assets into a revocable trust. So the bank can't collect that money from me until I die. When I die, then the bank can go after that money from the revocable trust. But if before I accumulate this debt, I've put all my assets into a revocable trust, nobody can collect anything from me until after I die. It's a little known happy feature of trust. The difference between a revocable trust and an irrevocable trust, two major differences. One is revocable trust can be changed by what's called the grantor. That's the person whose trust it is, the person whose estate it is. A revocable trust can be changed by the grantor anytime up until the time they die. So if 2 days before you die, you decide that you want to disinherit one of your relatives, but they're actually named in your trust, you can change your trust 2 days before you die and disinherit them if you want to. Or you can add somebody to your trust 2 days before you die and make them part of, make them a beneficiary for you. So revocable trust can be changed by the grantor up until the time of death. Irrevocable trust can't be. An irrevocable trust is a box that as soon as you put things into it gets completely sealed and can't be opened. A revocable trust is a box that can be opened up until the time you die. So if you put assets into an irrevocable trust before you die, then nobody can take those assets out of the box. Not your creditors. Your creditors have no access to them. So your creditors cannot claim against whatever's in that box. It's safe from creditors. But also it can't be changed. So if, for example, a few days before you die, you find out that one of your kids has been stealing from you all these years and you want to cut them out of your will, but they've already been named in the irrevocable trust, well, tough luck. If they're named as beneficiaries in the irrevocable trust, even if you find out that they've been stealing from you 2 days before you die, there's nothing you can do to change it. They're going to get whatever money they're named owed as beneficiaries. So for that reason, people don't like irrevocable trusts, for the reason that they can't be changed once they're set up. So by far the most common trusts are revocable trusts. That's more than 90% of all trusts. Because people get nervous when they do an irrevocable trust that there's something they might want to change that they just can't once they set it up. Now, one advantage of all trusts, regardless of which type you set up, is trusts do not involve court filings. So with a trust, you have to file it with an attorney, but you don't have to file it with a court. And there's no court filings after you die either. So that means that you can keep everything private. Nothing becomes public if it's in a trust. Nothing goes into a court document that other people in your family or outside of your family can access. So that for this reason, a lot of rich folks really like trusts because, even after they die, nobody can see what they had or who they left what to. Trusts do have executors, essentially. So the executor will obviously know, but they don't have to file anything with the court. So that information remains private. And because there's no court documents to be filed with a trust, trusts can be administered much more quickly and more cheaply. So for example, a trust is more expensive to set up than a will. You can set up a will for a couple $100, but a trust costs a few thousand to set up. However, if the will goes through probate, the probate costs, the attorney's costs, and the filing costs from the probate are going to be way more than a few $1,000s. And so ultimately, trusts are less expensive to administer than wills and probate are, because trusts don't involve court filings. And also because they don't involve court filings, they can be administered faster. Now, there's still mandatory waiting periods, and you still have to pay creditors, et cetera, from the estate if it's a revocable trust. But because you don't have these court documents and court timelines and judges' rulings to go through, trusts can generally be administered much quicker. The fastest I've ever seen a trust administered is maybe 4 to 6 months, but typically 9 months in California is about the length of time between the time a person dies and the time their trust is distributed. 9 months may seem like a long time, but it's a lot less time than the 1.5 to 2 years that a probate is going to take you. And I have seen trusts pretty much completely finished within 6 months of death. So it's significantly faster because, again, it doesn't have the court filings and legal proceedings of a probated will. So it's much faster, and it's less expensive in the long run to set up and administer. And you can specify things in a trust you just can't specify in a will. So remember, we talked about things you can specify in a will, but not a trust, like who gets custody of your kids. But there are things you can specify in a trust you can't specify in a will. For example, a trust can not only specify who gets what after you die, but in what time frame they get it, and whether they get it all at once or, for example, in annuity payments, yearly payments of a certain amount, and whether they can use it right away or whether they have to wait until they're a certain age. All of that can be specified in a trust, but not a will. Wills cannot specify an age a beneficiary receives your money, or how much they get per year or whatever. If you just have a will and it's probated, whatever you leave to any beneficiary, they get it all right away, automatically. If you want that not to be the case, you'll have to set up a trust. Because unlike a probated will, when probate is done, it's done. The executors, the judge approves the distribution, the executor is finished. So there's no one to continuously administer a probated will after the probate has finished. But if you're talking about like not giving somebody all their money right away, you're going to need somebody to oversee that process of distributing the money over years and years and years. And that can only be done through a trust instrument, because with a trust, until everything is gone from the trust, the executor is still responsible for the trust and can still administer it. So even 10 years after you die. Okay, so again, I hope that I've clarified things. I know we got pretty deep in the weeds with a lot of legal stuff. 6 different ways that you might inherit an estate or part of an estate. A small transfer if the estate has a will, but it's valued below $200,000. The rules of intestacy if the estate doesn't have a will or a trust, and it's actually at any valuation. Pay or transfer on death accounts, which can transfer right away, but you can only name one beneficiary per account. A probated will, which is basically where you have a will and not a trust, and the value of the estate is more than a couple $100,000. Probated will is a long legal process that is cheap to set up but very expensive to administer, and goes on for a very long time before your beneficiaries get to see their money. In a will, you can then have a will and a trust, which goes a bit faster and is in the long run cheaper than probate, and it's also much more private. And among the trusts, there's the revocable trust, which can be changed by the grantor anytime up until their death, or an irrevocable trust, which can't be changed by the grantor once assets have been put into the trust. Most people, for obvious reasons, like revocable trusts because they like the idea that they can change it if the circumstances change. But regardless of which kind of trust you use, it's a faster process and a more private process than probate. Typical trust takes about 9 months to administer. That is, to distribute at least all the initial assets from it, which seems like a long time, but it's a lot better than 1.5 to 2 years. Okay. So, tempted to ask you if you have any questions. Once again, I'm going to do the disclaimer. I am not an attorney, not an estate attorney or any other kind of attorney. I know about a lot of this stuff because I've had to deal with it in my personal life with, the passing of my relatives and, creating my own trust and will. So, through just personal life experience, I've, experienced all of these different types. But if you have, as always, if you have technical or specific questions, you want to talk to a real trust and will attorney, a real probate attorney or estate attorney, which I am not. Okay, so there's that caveat for you. But I hope I've clarified things a little bit for you as far as how things can be passed on to beneficiaries after you die. So hopefully this was informative and helpful for you. Okay, take care.